Hello, and welcome to the second lecture on the sources of international human rights law. In the previous lecture, we spoke about the consensual and superpositive bases of international human rights law, and we explored a variety of doctrines relating to treaties or international agreements. Today, we'll talk about other sources of international law, in particular customary international law, and also other concepts such as jus cogens and soft law or non-binding norms. And we'll talk about, for each of these categories, the advantages and disadvantages of protecting human rights through one of these sources or legal rules. Now we'll start with customary international law. And I've put up the canonical definition of customary international law on the slide, which you can see is the widespread and consistent practice of states that is followed by those states out of a sense of legal obligation, known by the Latin phrase opinio juris. As you can see already, we have two Latin phrases, and there will be a few in this course that are widely accepted by international lawyers and legal scholars, but I'll try to keep them to a minimum. So these two elements, what do they actually mean? Well, they break out into an objective element and a subjective element. So let's talk about each of those in turn. First, the objective element of customary international law. And here we are examining the actual practice of government officials, either in written form or in conduct or in oral statements. And you see before you on the slide a number of different examples of what are known as state practice. And again, state practice has to be widespread and consistent in order for there to be the possibility of a rule of customary international law. The second element of custom is a subjective element, and it is conduct or statements by government officials which evidence a belief that certain actions or inactions are legally required rather than merely convenient, desirable, politically expedient, and so forth. And again, I've put up some examples of such conduct or statements. Now, before we go forward, you might be wondering, why would any legal system treat as a binding rule a practice that has evolved as a result of conduct or statements rather than written agreements, such as treaties? And the answer to that, in part, is that the international legal system does not always provide opportunities for states to come together to negotiate all of the legally binding rules that they might want to adopt to regulate their conduct with each other and with respect to the individuals within their borders. And so custom, or customary international law, or CIL, is in that sense a kind of gap filler. It's also a background norm, such that when states behave in a regularized way and begin to treat each other's actions as if they are legally mandated, that becomes a source of future legal obligation. Since we don't have a single international legislature or executive branch, we need custom as a way of decentralized lawmaking by the nearly 200 nations in the international legal system. So that's a brief discussion of custom. I want to now introduce you to some of the specific human rights that are widely believed to be part of customary international law, and they include those that are listed on the slide before you. We will spend some time in this course talking about genocide and also about consistent patterns of gross violations of internationally recognized rights, as well as some of the other rights that you see listed here. Now, the source for this assertion that a state violates customary international law if, as a matter of state policy, it practices, encourages, or condones this sort of conduct, comes from a source known as the Restatement Third of the Foreign Relations of the United States. And it is the equivalent of a kind of compendium of what is understood to be widely accepted as the law. And you can imagine that a restatement such as that could be quite important when what it's doing in part is collecting evidence and synthesizing evidence of state practice and opinio juris. So let's step back and evaluate a bit and think about what are some of the advantages and disadvantages of CIL or custom. Some of the advantages are that custom is supported by both the consensual and superpositive bases of international law that were mentioned in the previous lecture. In particular, all states either participate in the formation of custom or have the opportunity to do so if they have an interest in the particular matter. So in that sense, it's consensual, but it also has the capacity to bind all states, including states that remain silent or on the sidelines with respect to a custom that is forming. So in that sense, it's linked to something other than a consensual basis of legitimacy and legal obligation. Another advantage is that custom is progressive and flexible. It evolves in response to changes in global affairs, changes in morality, and so forth. So that's an advantage over treaties, which would have to be renegotiated or amended. But custom also has a number of disadvantages. In particular, it's unclear how widespread state practice has to be before a customary rule can be considered to have formed. In addition, there's a risk that some courts or scholars could find CIL without sufficient evidence of that widespread and uniform state practice or of opinio juris, which would either undermine or perhaps be in tension with the consensual basis of international law. And in addition, states often violate human rights that are protected by customary international law. But at least in response to that last point, I would say that states also violate human rights that are protected in treaties, so that criticism perhaps proves too much, although it does suggest a larger challenge about how to respond to violations, which will really be at the heart of this course. Moving on now from custom, I want to take up the concept of jus cogens, and for those of you who'd prefer to avoid the Latin, peremptory norms. What are these jus cogens or peremptory norms? Well, here again we can refer to the Vienna Convention on the Law of Treaties, the VCLT, and there we find a definition of peremptory norms as being norms of general international law that are accepted and recognized by the international community of nation states as a whole, and from which no derogation is permitted. Now that's a fairly formal sounding definition. Here's a more practical application of the same idea. Really what we're talking about with jus cogens or peremptory norms are higher order legal norms. And really we're talking here about a label that is placed on those norms whose perceived importance is so great that they are acknowledged universally or nearly universally to be superior to other norms and rules. Now, you might imagine from this description that certain human rights might very well fit the definition of jus cogens. And in fact, that's the case. Quoting here again from the Restatement of Foreign Relations Law of the United States, you see what I would say is a widespread agreement that jus cogens norms include many of the norms, or I would say all of the norms that you see on the screen before you. So this is obviously a legal doctrine that is quite important to those studying customary international law. But again, let's step back for a moment and talk about advantages and disadvantages of this form of international regulation. So advantages include the fact that jus cogens is very strongly supported by the superpositive basis of international law. It appeals to the idea of higher order legal principles. It also is obligatory in the sense that states cannot opt out from it, nor can they adopt a subsequent legal rule like a treaty or ordinary custom that would supersede jus cogens. And in fact, the accepted doctrine in international law that any customary rule or treaty or domestic statute for that matter that conflicts with jus cogens would be void. So those are some of the advantages. Some of the disadvantages include some similarities to what we saw with CIL, and that is that international law doesn't provide a clear method to identify which human rights are jus cogens, and that again can lead to claims that a particular human right is jus cogens without a strong evidentiary basis. There's a bit of a paradox here if you think about it. If there is a claim that a particular human right is jus cogens, then presumably that right should always be respected. But in fact, claims about jus cogens often arise in the case of violations of a particular human right. So it may be that there is an existing human right, but that one or a handful of states deviate from that right in a way that other states in the international community find to be objectionable. So that's a concept that we'll explore more as we move throughout the course. And again, the concern here is in general, if you have overclaiming with respect to any legal norm, you have a risk of backlash by governments. I now want to turn to the third topic for today's lecture and the final topic, and that is the idea of non-binding norms, which are sometimes referred to as soft law. And soft law is, I think, a problematic label, but it's one that's stuck, so you need to know it. And the basic idea here, though, is we're talking about an international instrument or document that uses legal language but doesn't create legally binding obligations. Now, this may strike you as perhaps even stranger than custom, in the sense that why would states use legal language but not make something legally binding? It's in fact quite common to see this in interstate relations and in the activities of non-state actors such as non-governmental organizations or human rights advocacy groups. And indeed, here are some examples. If you think about the UDHR, the Universal Declaration of Human Rights that we talked about earlier, that is an example of soft law. And the reason it was soft or non-binding was precisely because it made it easier for governments to agree on a set or catalog of rights and freedoms that ought to be protected, even if they couldn't, or at least couldn't yet, agree on making those norms legally binding. So that is one of the advantages of soft law, and you see some others. There are ways of testing out particular norms or ideas. They are ways to experiment, if you will. They have an even more flexible and adaptable characteristic than would customary international law. A document or declaration that's promulgated and widely adopted could become a standard of behavior, even if it's not legally binding, quite quickly. So if the situation that's being regulated is uncertain, or it's uncertain whether domestic approval, formal approval of a treaty would be forthcoming, or if we want to have participation by a range of non-state actors as well as states, soft law has a number of advantages. You won't be surprised to learn that we'll also consider some of the potential criticisms of soft law. Its uncertain legitimacy is one. Some confusion over whether a particular conduct is just encouraged or only legally required. In other words, the line between soft law on the one hand and a treaty or custom on the other could be quite thin in some contexts. There might even be conflicts between soft law and treaties. We'll see some of those in the next few weeks. And also the possibility of increased violations by states, in part because there are no established enforcement mechanisms for most soft law instruments. With the discussion of custom, jus cogens or peremptory norms, and soft law, you now have a basic understanding of the sources and ground rules of the international legal system. And that will prepare you for the specific discussions that we will have over the coming lectures. For now, I'll leave you with some sources for additional information about customary law and soft law, and those links are available to you if you click on the PDF on the course website.